All right, welcome back. We've got another fun episode making fun of Delete Lawz and his utter ineptitude. But before we get into all that, before we do, do you all like my? I figure in honor of Delete Lawz and his bang fashions. You like it? Yeah. I'll roast if I don't take that right off. So that isn't actually my jacket. That is my mom's jacket that she has had for at least 30 years. She's actually received compliments from young ladies who appreciate its retro charm. uh, but speaking of Delete Lawz and his ridiculous jacket, so yes, I have seen his recent arrest. No, I'm not going to cover the video, react to the video. It's unnecessary. It's so my expert analysis of the arrest, though, just from the video. Number one, here's what you've got to look at as a lawyer. Number one, was it a valid arrest? It was there probable cause for the arrest? And then, especially with Delete Lawz, the second issue you've got to look at is, were his rights violated? Those, I think, are pretty easy answers. Number one, there was probable cause. Did he need to be arrested? Probably not. Is he going to be convicted? There's a good chance. But he didn't need to be arrested. Although, that being said, as I've said many times in the past, when dealing with sovereign citizens, you always arrest if there's probable cause. And you never drop it, you always prosecute, don't give them an out. Um so in general, he didn't need to be arrested, but it's a good arrest. It's a valid arrest. Since it's a valid arrest, his rights weren't violated. Even if he's not convicted, his rights weren't violated. There was probable cause. E- There was probable cause. Even if it's not reasonable doubt level, there was probable cause, and that's all there needed to be to make the arrest. So sorry. Um, and I've been checking Pacer throughout the day because I'm sure all of you saw the day after he was arrested, he went out harassing the same cop and shouting at him on video, "I'm gonna sue you on Monday morning." Well, it's late Monday night, still no lawsuit. So, will there be? I imagine. But he threatens lawsuits more than he files lawsuits. And he files a lot of lawsuits, but um so if he files, when and if, I will cover it. But yeah, that's where we are right now. So the main course for today is well, this document I've already covered most of it. In fact, I don't know that it's changed all that much since I covered it. This is DeCastro versus Catherine Peter, Daniel Clement, Michael Piratini, David Omo Jr., and Doe's 1 to 30 inclusive. So, exact same lawsuit that I already covered. This is the California State Court lawsuit where Delete Lawz is suing Kate. And to my knowledge, he's changed it a little bit, but the big change is he's added parties that he already knew the names of. Remember, when he filed, he said, "This is against Kate Peter and John Doe's 1 through 30." And then he proceeded to name a bunch of those John Does in the lawsuit, in the body of it. He knew their names. He used up his free amendment to add a few of their names. It's ridiculous. So, since I've already covered it, I'm going to speed through it. I'm still going to give my analysis. It's not going to be as in depth as the first time, but I realize, even though I watch Masshole and Blue Bacon and Team Skeptic, I realize there the Venn diagram of who watches those channels isn't a circle. It's a three-leaf clover. It's not a perfect overlap. So, for those of you who don't know who Kate is and don't care who Kate is, but watch Team Skeptic and watch Blue Bacon, hi, welcome. I'm Joe. I'm a Utah-based attorney, and I've been covering Delete Lawz and his lawsuits against Kate for several months now. So speaking of me being a Utah-based attorney, so I know not all of you care for Merb. I am going to shout him out though for two reasons. Number one, like I said, I'm a Utah-based attorney. Merb is a California-based attorney. He's licensed in California. I'm not. He Watching his videos, you get a little insight that I don't have, such as California is a you've got to plead facts, whereas most other states are notice-based pleading. So, for those of you who have followed me for a long time, you've heard me refer to the Twombly-Iqbal standard for Rule 8 of the Federal Rules of Civil Procedure, and how you've got to lay out at least a bare minimum of a case. It can't just be bald assertions. You've got to have a case, but you don't have to lay out every little detail. You've got to bring facts in California State Court, according to Merb. The other thing I'm going to call out Merb for, so he Googled the Honorable H.J. Ford III, the judge hearing this case. Now, we know that the Honorable H.J. Ford III must be an excellent judge because he graduated from the S.J. Quinney College of Law at the University of Utah in 1987. I graduated from the S.J. Quinney College of Law at the University of Utah after 1987. So, I may be biased, but I'm sure he's an excellent, excellent judge. With that, let's jump into the complaint. So, as I mentioned, it's DeCastro versus Peter, Clement, Piratini, Omo, and Doe's. And it's First amended complaint, as a matter of course, per California Civil Procedure number or section 472. And it's for civil defamation, stalking, harassment, tortious interference, and right to publicity. Comes now, plaintiff Jose de Castro hereby brings this first amended complaint against the above named defendants and requests a settlement meeting and or conference and alleges on information and belief as follows. He's really hoping to get a settlement. He really I mean, he's terrified, absolutely terrified of discovery. Cuz in discovery, he I think he realizes that discovery includes depositions because he said, "I can't wait to get so and so in a deposition," not realizing, of course, that he'll also have to sit for a deposition. But what else is involved in discovery? We've got requests for admissions. So, what's going to be the number one request for admission? Were you know, did you enter into a deferment agreement on such and such date for the manufacture and sale of GHB? Yes or no? If he answers no and they, bring the record, that's perjury. He's got to answer yes. If it's true, of course. Um the interrogatories, provide us with your criminal record. Your entire criminal record include dropped cases, deferred adjudications, convictions, um, charges where you fled and they were administratively dismissed due to non-prosecution because you fled. Include all warrants, include all protective orders, restraining orders. He's terrified of discovery. It's the violating process. A violating process. And I'm not going to spoil it, but it'll be very violative if we get to it. If we get to it. But as we've seen, he tends to, well, number one, his cases get dismissed on 12B motions or whatever the California state equivalent is, because their rules of civil procedure don't follow the federal rules, at least as far as numbering. Um, but then you look at the Massachusetts federal case against Kate and Josh, he's all but abandoned it. He's terrified of discovery. He he sues hoping that people are intimidated by him and will settle. Number 1, no one's intimidated by his lawsuits. But number 2, his demands are so outrageous that no one would settle anyway. Uh, it's asinine. But let's jump back to it. Introduction. Plaintiff was employed as a constitutional activist and media content creator after studying and teaching constitutional law for over 20 years. Yeah. Although plaintiff has been arrested many times while exercising his constitutional rights to protest against racial inequality and the despotism state America has obviously become, plaintiff has not been convicted of a crime while protesting or otherwise. Plaintiff's only misdemeanor criminal records are historically over 20 years old. Um, I can think of one that's a week old. I can think of another that's under a year old. No conviction yet because he fled. There's still an outstanding warrant. Defendant Catherine Peter is a self-described internet troll, which so that runs an online organization called Masshole Troll Mafia that is indeed an illegal criminal enterprise. It's not. It's not. It's not. I mean, he doesn't explicitly say it, at least not yet. But criminal enterprise is hinting at Rico. As I've said, when I eventually start a merch shop, probably my first piece of merch is going to be it's never Rico. Because Rico, for those of you who enjoy House, the television show, Rico is the legal equivalent of lupus. It's never lupus in House, except for that one time when it was. In legal proceedings, it's never Rico, except those very, 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 very rare cases. And in civil, it's very rare. Trolling is not simply with harmless online pranks. Trolling includes, but is not limited to, harassing, stalking, and vandalizing targets. Peter identifies a target. In this case, the plaintiff is the target, and then the criminal activities begin. Peter has done this for years. Plaintiff has vowed to be the last victim of her illegal activities. None of those others are relevant. They are not plaintiffs here. So, who cares? All Peter need do is identify a target, and the nightmare for them happens in an amorphous action of the organization's members, hiding behind internet anonymity, as well as state and country borders for protection. Peter coordinates and facilitates the coordination of harassment and stalking of plaintiff and his relations. Peter, herself, and through her agents have conspired together and committed the following crimes and torts on plaintiff. 1. Defamed him by YouTube video and written article, by email and telephone calls. 2. Defamed his products by YouTube video, Reddit, Facebook, Twitter, and by written article, by email, and by telephone calls. 3. Interfered with his contracts and prospective economic advantage. 4. Stalked him online and in person, harassed him online and in person, trespassed, assaulted, and battered him. 5. Used his name, voice, and photograph or likeness for unauthorized commercial use. And 6. Committed wholesale copying of his creative content. That sounds an awful lot like a copyright claim, which state courts don't have jurisdiction to hear. These tortious acts were committed with malice aforethought. Um, okay. Well, I assume he says malice aforethought because he thinks in order to sue as a public figure, there's got to be actual malice, which is different from malice aforethought, which is a criminal concept, and it's pretty rare criminal concept at that. But um, as defendants knew that they would cause him harm, and they did cause him economic harm, emotional harm, and physical harm, and will continue to cause him harm in the future. Plaintiff warned Peter for over 6 months before finally taking legal actions against her and her troll mafia. Jurisdiction you. General jurisdiction is proper in this court because the unlawful practices alleged herein were committed by defendants within the county of Los Angeles, and the harm occurred within that county, and the amount of damages sought exceeds the minimum jurisdiction of this court. Um, as we'll find out, the vast majority of the stuff didn't happen in LA. In fact, there's only one named defendant that did anything in LA, and it, yeah, it's ridiculous. So let's see, I'm on 5. This court has general personal jurisdiction because significant parts of the stalking, harassment, assault, and battery occurred in California, primarily in the county of Los Angeles. Defendants' emails and phone calls to California have been substantial, continuous, and systematic. At least one of Peter's agents is believed to be a resident of Los Angeles County. No, just no, no. Um, for starters, for starters. Well, this is one of the problems. He brings up this just shows he didn't actually amend the complaint because he's still trying to tie everything back to Kate, one of Kate's agents, instead of just saying at least one of the defendants lives in Los Angeles County. But uh, the rest of the defendants have, to my knowledge, virtually no contact with Los Angeles County. No, that they don't. The court just doesn't have jurisdiction over them. Now you may say, "Well, hang on, Joe, because I'm covering the Schofield versus Giard trial." Well, lawsuit. It's probably not going to make it to trial, but that's the TikTok psychic being sued by the University of Idaho history professor for defamation in Idaho federal court, even though the defendant is from Houston, Texas. This is the TikTok psychic accusing the professor of committing the University of Idaho murders. Um, well, the difference is the difference is the entire defamation in that case is concerning events that occurred in Idaho. So all the witnesses are in Idaho. Virtually none of the witnesses for this are in California. The long arm statutes don't apply. They are limited. So let's move on. This court has specific personal jurisdiction because alleged source witnesses for Peter and her agent's defamation are allegedly in the county of Los Angeles. Additionally, the alleged judicial record cited for the defamation as alleged fact is a judicial record of the county of Los Angeles. Um, yeah, that's not enough to give long arm jurisdiction, that personal jurisdiction. It's easy enough to get those. I mean, you you're not even going to need anyone from the county of Los Angeles to testify about the court records because not hearsay because they're official records. At at worst, you get the custodian of the records on Zoom in court wherever to say, yeah, these are our records. Done. They're admitted. Venue is proper in this court under California Code of Civil Procedure, Section 395, because plaintiff is a resident of the county of Los Angeles. and the events or omissions giving rise to these actions occurred in the County of Los Angeles. Additionally, this court offers online filing, which makes it more convenient for foreign parties that are part of this action due to California's long arm statutes. Well, number one, his mailing address is in Los Angeles County. It so it probably still is his domicile because there's a whole big analysis where it's where you live, have the intention to return, and well, it's a whole big thing. Um, but he says he's a resident of Los Angeles County, but he also mentions later all his different residences over the course of the alleged tortious conduct, and they're not in Los Angeles County. And he says online filing, which makes it more convenient for foreign parties. Yeah, no, no. I mean, thank you to those of you who do search the docket on this case and send me the filings. Los Angeles well, California, do better. Do better. Your your online court records could be a lot easier. And it's not free for parties to file in California. It's not free for them to access. It's not convenient. It's just not. Parties. Plaintiff Jose Chilito de Castro is, and at all times herein mentioned, was an individual residing in Santa Monica, Los Angeles County, California. Plaintiff operates the YouTube channel Delete Lawz. Plaintiff is informed and believes, and on that basis alleges, that defendant Catherine Kate Peter is an individual residing in the state of Massachusetts, county of Bristol. Peter operates the YouTube channel Troll Mafia Official. Peter has said in the past, when harassing and stalking plaintiff's family members, plaintiff's investors, and other associates, that she did not act alone. Rather, she conspired with others, or through the doctrine of agency, did cause this harassment to occur. Peter runs an online organization called Masshole Troll Mafia that is indeed an illegal criminal enterprise that trolls, harasses, stalks, vandalizes, assaults, and batters targets that Peter identifies. All Peter has to do is identify a target, and the trolling happens in an amorphous action of the organization's approximately 3,000 members, hiding behind internet anonymity as well as state and county borders for protection. Peter coordinates and facilitates the coordination of harassment and stalking of plaintiff and his relations by her agents. Well, that's the second time we've seen that paragraph. And I think it's a good time to bring up agency law. Because all through this, he says, this person is Kate's agent. This person is Kate's agent. This other person is Kate's agent. They're not Kate's agents. Um, but the best place to look for why is California's agency law. And that's California Civil Code, section 2295 through 2300. Definition of agency. An agent is one who represents another, called the principal, in dealings with third persons. Such representation is called agency. Any person having capacity to contract may appoint an agent, and any person may be an agent. An agent for a particular act or transaction is called a special agent. All others are general agents. An agency is either actual or ostensible. That's one place where California law differs from real law. Well, So in most states, well, I shouldn't say most states. I don't know most states' laws. Um, but under the the model laws, what they teach in law school, what they teach on the bar, it's actual or implied agent instead of actual or ostensible agent. So an agency is actual when the agent is really employed by the principal. So, well, Kate doesn't have any actual agents as far as we know. So that would leave ostensible agents. An agency is ostensible when the principal intentionally or by want of ordinary care causes a third person to believe another to be his agent who is not really employed by him. So in this case, it would be the want of ordinary care. By want of ordinary care, did Kate cause Delete Lawz to believe other people were her agents? Well, he is going to claim yes. Let's see. I on a different screen, law school agency law outline open. Right section. And I said implied authority, apparent authority. Um, so uh, basically, in order for there to be an ostensible agency, so a reasonably prudent person would have to believe that there is an agent. Um, and that would be manifestations pertaining to the agent's authority by or attributable to the principal. So, has Blue Bacon ever said, "I'm acting on Kate's authority by on her instructions. She controls me. She's" no, no. Neither has Team Skeptic. Neither it's asinine. And it's just yeah. I've already spent too long talking about agency. It's a complicated subject. Needless to say, from what I have seen, Kate doesn't have any agents. At least none who have interacted with Delete Laws, and none that he's identified. If we're going to get to the Kate's Tea Party event, if he has proof that Kate sent someone to do that, they'd be her agents, probably. But he has no proof that Kate's well, number 1, I don't believe that anyone actually did that. I believe he did it. It's a false flag. But number 2, he'd have to bring proof that Kate instructed someone to do it. He won't be able to. But let's jump back to the complaint. Plaintiff is informed and believes, and on that basis alleges, that defendant Daniel Clement is an individual residing in the state of California, county of Los Angeles. Clement is an agent of Peter. No. Plaintiff is informed and believes, and on that basis alleges, that defendant Michael Piratini is an individual residing in the state of Washington, county of Pierce. Piratini is an agent of Peter. And that's just laughable because at this moment, as far as I know, Kate and Blue Bacon don't get along particularly well. At least, yeah. Um, Piratini has hidden behind a false identity for many years, running a troll channel on YouTube called named Blue Bacon, where he harasses people, including plaintiff, behind a false identity, pretending to be a private investigator and military police officer. Um, Couple things. Having an alias online is not a bad thing. I mean, it certainly doesn't open you up to tort liability. It's a smart thing to do. Uh, Delete Lawz doxed him. That's kind of a bigger deal. And pretending to be a private investigator and military police officer. You better back those up. Although, of course, there is yeah, putting it in a court filing is a good way to avoid being charged with a defamation suit. Plaintiff is informed and believes, and on that basis alleges, that defendant David Omo Jr. is an individual residing in the state of Texas, county of Dallas. Omo is an agent of Peter. Omo has anonymously run a troll channel on YouTube named Team Skeptic, where he harasses people, including plaintiff. Omo has a felony conviction for manslaughter, and plaintiff attacks his credibility under California Evidence Code Section 788. Well, now, there are a couple of problems with that. Team Skeptic was doxxed by Delete Lawz. Number 2, Delete Lawz on video has repeatedly called Team Skeptic a murderer. Murder and manslaughter are two different things. Prepare for a counterclaim, maybe? Um, and number 3, you're attacking his credibility under California Evidence Code 788. Um, Premature. So, what is California Evidence Code 788? Well, it's going to be basically the same thing as in the federal rules of evidence, where you're only able to use a, an opponent's or any witness their prior criminal convictions for limited reasons. And generally, that's going to be to attack their credibility. So the one of the big reasons for that is, especially in criminal, if it's a defendant, both in criminal defendants and civil defendants, you don't want the jury to say, well, they were convicted of this bad thing, so they must be guilty or responsible of this other bad thing. I mean, just look at the recent Murdoch trial. Uh, Murdoch testified, which was dumb of him, and he opened him up self up to cross-examination where the prosecution just buried him, absolutely buried him with the criminal charges he's facing for theft, crimes of moral turpitude, crimes of dishonesty. And here's the thing that this, his Delete Lawz attacking Team Skeptic's credibility, like I said, is premature. It's it'll come up if it goes to trial. This would be litigated in a pretrial motion. Either Team Skeptic will bring it and as a motion in limine saying, "Hey, I have this. I don't want it coming in. Exclude this." Or Delete Lawz will come in with a motion saying, "Hey, Team Skeptic has this. I want to make a huge deal about it." Well, the most he's going to get is on cross examination, he's going to say, "Team Skeptic, do you have any criminal convictions?" Yes. All right, move on. I- If for those of you who watched the Daryl Brooks trial, um, there were a couple of witnesses who had criminal convictions, prior criminal convictions. You'll remember Judge Doro instructed Daryl Brooks, you may ask them if they have a criminal conviction, you may ask them how many, and then move on. And in general, you're I can't speak for California. It's the federal rules that they teach in law school. You can ask about crimes of moral turpitude and crimes of dishonesty are generally available to ask about. But other crimes, if they're over 10 years old, chances are you're not even going to be able to ask about them. So, yeah. The true name or capacities, whether individual, corporate, associate, or otherwise, of defendants DO 1 through DO 30 inclusive, are unknown to plaintiff, who therefore sues such defendants by such fictitious names, and will amend this complaint to show their true names and capacities when ascertained. You already used up your one free amendment. Funny enough, on those whose names were already in the body of the complaint. So, and there are a couple more that were already in and are still in that you could have mentioned, but are still does for some reason. And I don't know why. Um, so are unknown. So he sues by the fictitious names and will amend to show their true names and capacities when ascertained. Plaintiff is informed and believes, and thereon alleges that each of the defendants designated as a doe is negligently responsible in some manner for the events and happenings herein referred to, and thereby proximately caused injuries and damages to the plaintiff as herein alleged. Facts common to all causes of action. Yeah, facts. The allegations of this complaint stated on information and belief are likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. Except he'll never allow it to go to discovery because he's terrified of that. Plaintiff is informed and believes, and thereon alleges that at all times herein mentioned, defendants Doe 1 through 30 were agents of each other and the named defendants, and in doing the things alleged in this complaint, were acting in the scope and of such agency and with the permission and consent of defendant Catherine Peter. Peter is the owner, operator, and user of a group messaging platform on the Discord's service. The Discord is used by masshole members to conspire directed harassment attacks on multiple victims. The harassment includes email, telephone, and public sharing of personal information that can further be used to harass those individuals, called doxing. He's doxed two of the defendants. Crimes against victims don't stop at harassment, but include vandalism, stalking, harassment of victim family members and employers, and assault. Employers? When has he ever been employed? There are over 2,800 masshole members on the Discord account, owned and operated by Peter. Sharing of images, text messaging, and voice chat is available on the Discord. Peter has admitted to tracking plaintiff on the server like an endangered great white on the Discord. He loves that statement, even though it means absolutely nothing. First cause of action for libel, slander, and false light. Plaintiff against all defendants. Even though those are three separate causes of action, but they're all in the first cause of action. Plaintiff incorporates by reference paragraphs 1 through 17, inclusive as though fully set forth herein. Plaintiff, who previously enjoyed a good reputation in the community. Which community did he enjoy a good reputation in? None that I know of. Certainly, he didn't have a good reputation by the time he came to Kate or Blue Bacon or Team Skeptic's attention. He'd already been run off of TikTok for his allegedly racist behavior, for being a white savior, in essence. But he enjoyed a good reputation in the community, was defamed by defendants' assertions that he had once sold the date rape drug and might be a snitch. Will sue us for mocking him. Well, you were charged with selling GHB, which is one of the date rape drugs, in addition to others. The fact that you got a diversion, which the court in Massachusetts, when you tried to get a restraining order against Kate and Josh, that Massachusetts state court was able to see you got a diversion agreement for that. So we know it exists. And getting a diversion agreement on that serious of a charge, well, it would be a reasonable assumption that you got that diversion agreement by being a state witness, being a confidential informant. And she said, might be a snitch anyways. She's theorizing. She didn't say you are a snitch. She said, might be a snitch. Will sue us for mocking him. How many lawsuits is this now? She was right about that. A screenshot of the publication containing the defamatory statements is attached to this complaint as Exhibit 1. Such assertions were published to at least one third party, and that YouTube video was viewed 12,716 times as of February 1st, 2023. The number of times the title of the video was read is not available until after discovery. Additionally, the video shows up in search results for Chili de Castro, plaintiff's well-known nickname, Jose Maria de Castro, and Delete Lawz, plaintiff's brand. So you'll notice this is a count against all defendants. All defendants. Even though it's just Kate. The title of the article constitutes libel per se, and statements in the video made by Peter and Piratini. Blue Bacon, Blue Bacon made his own video. What was he on that one? That was almost a year ago. Hmm. But apparently, they constitute slander per se, in that they use inaccurate documents acquired from Been Verified in violation of their terms of service, partly because of known accuracy issues. A consumer information service presented as judicial record to assert as factual that plaintiff was convicted of a crime that he in fact did not commit. Well, as Kate has said, and Blue Bacon has said. Well, Kate has said she starts with these public service searches. And when they come up with hits, she goes to the primary source. She goes to the arrest record. She goes to the court records. The fact that the court records were sealed is one of the reasons she thinks you're a snitch. Delete Lawz is not in privity of Been Verified's terms of service. So even if Kate violated their terms of service, that's irrelevant because that's between Kate and Been Verified. And like I said, if she starts with that and goes on to get records, get the arrest record, get the public record, that's great. And Blue Bacon has said he's never used Been Verified, at least not on this. He's got better sources at his disposal than that. And you may well not have committed the crime. But but there's a deferred adjudication, deferral or basically he the Massachusetts court even had it in their records. They were able to get it. It's there. So diversion, that's the word I was looking for. A diversion is a deferred adjudication. In order to get a diversion, you've got to go in front of the judge. How do you plead, Mr. Defendant? I plead guilty. And then the judge takes that guilty plea and puts it in his desk drawer. And the minute you commit another crime during the period in that diversion, it springs out of the judge's desk and says, "Oh, you're guilty, and now you pled guilty. Now you are guilty." But he managed to be a good boy for a little while, and instead it fell out the bottom of the desk drawer into the shredder. That's how diversion agreements work. Such statements damage plaintiff as a natural consequence of the words and amount to libel per se and slander per se. Such assertions were false because plaintiff was never convicted of, nor did he plead guilty to selling any drug, especially a date rape drug. Um, she never, Kate and Blue Bacon, as far as I know, never said, they never said conviction. I mean, even let's even scroll. Once sold the date rape drug and might be a snitch, will sue us for mocking him. She said, "You were charged." She never said you were found guilty. She never said you were convicted. There's a difference. But as you would have had to enter a guilty plea to have the diversion agreement accepted. So, yeah, I don't believe you. Um, and like I said, GHB, go to the DEA website. GHB is regarded as a date rape drug. It it's used as one. Roofies are as well. The fact that one is a date rape drug doesn't mean the other is not. And you not using it or claiming to not use it as such, you can say, well, yeah, I had GHB, but I used it as a workout supplement, as a recovery supplement. That doesn't mean other people don't use it and it's not regarded as a date rape drug. In fact, in the video, Peter claims that she is unable to get a record from the government. Instead of recognizing that the record doesn't exist, to add to the sting of the story, she asserts that this must mean that plaintiff is a snitch. Her the trail goes cold. If there's an arrest record and Delete Lawz saying, "Yeah, I paid Robert Shapiro $50,000 to defend me when I was no knock raided around this time period," and then the court records are sealed. Like, there's a difference between if Kate goes and says and submits a record request to the court and says, "I want the records on this court case." And if they say, "Well, that doesn't exist," that's a big difference from, "Sorry, we can't give that to you." That's sealed. There's a difference. So, yeah. Even Peter's record from Been Verified shows only an arrest and not a conviction. And that's what she says. That's what she says. That's exactly what Kate says. As an activist, plaintiff is often arrested, but has not been convicted. And this country's constitution is based on the principle of innocence until proven guilty. Um, she never said you were convicted. Furthermore, yeah, you are innocent until proven guilty. But there's a difference between innocence and not having done something. It's the arrest record that Peter pulls from Been Verified shows pos, pos slash per f slash sale narc slash c slash sub. To add to the sting of the story in excess of the actual alleged judicial record, Peter alleges having spoken to 4 witnesses in Los Angeles County that say that the drug involved was GHB. Peter, with even additional malice to add more sting than the actual story, falsely asserts that GHB is primarily used as a date rape drug. It's used as one. As a direct and legal result of Peter's publication of false assertions, plaintiff has suffered the following damages in respect to his property, business, trade, profession, or occupation. Damages in the amount of approximately $50,000 of compensatory damages and special damages, according to proof related to emotional distress. Remember how I said discovery is going to be even more invasive? Well, he is claiming damages based on emotional distress. The defendants are probably going to request the court force Delete Lawz to get a psychological evaluation, because He's claiming emotional distress. That's going to be invasive. Now, remember, eh, n- this is one area. It's going to be violating him. Kate and Blue Bacon and Team Skeptic and uh, Daniel Clement, at least at this point, are not going to have to do the same in Discovery. Well, how is that fair? Making one party do it and not the other. Here's why. Remember back, this trial is just so lovely because it, it's got an example for everything. The Johnny Depp Amber Heard trial. If you recall, Amber Heard was required to sit down for medical, psychological evaluations before the trial for Johnny Depp's doctors. But Johnny was not required to do the same. And the reason is Amber was claiming damages based on emotional distress. Johnny was not. So Johnny didn't have to sit for an evaluation. Instead, we got Dr. Doofenshmirtz, whatever his real name was, pontificating and just being just an abject quack, guessing, saying, well, this is what I've seen of Johnny in interviews. He never analyzed Johnny, and that could be a problem for him. It was certainly a problem for him on the stand. So, assuming this goes as far as Discovery before he abandons it, this could be very uncomfortable for Delete Lawz. Statements were not privileged because they were published to YouTube and not to an internal method between people with a shared interest. Plaintiff demanded a retraction within the statutory period, and a retraction has still not been published. Instead, Peter said, "Sue me." See her video titled, "Still Waiting for My Lawsuit," in Exhibit 3. Defendant knew that such statements were false, or acted with reckless disregard as to their truth or falsity, in that she knew that she did not have an official judicial record, yet she didn't even report accurately on the record that she did have from the consumer database. I believe she did, from what I saw. Second cause of action for battery, plaintiff against all defendants. Plaintiff incorporates reference by reference, blah, blah, blah. On May 30th, 2022, Peter traveled to the Memorial Day parade in Boston. It wasn't in Boston, it was in Stoneham, Massachusetts, so you're wrong there. Just to confront plaintiff. In her YouTube video titled, "Chili, I'm sorry that I upset you. Josh Abrams is my knight in shining puma." Recorded on that same day, she admits to this. Additionally, there are witnesses in the video that describe the existence of video evidence showing that she battered me multiple times. Where are these witnesses? Everyone I saw uh, would agree that he battered her. But uh, and remember, this is against all defendants. That Big Mean Kate has subjected Blue Bacon and Team Skeptic to liability here. In the video, Peter states, I'm driving across town and checking in with Discord. Is he still there? Is he still there? Because he's squirrely. I went down there to have a confrontation with him, and he isn't getting away until that happened. At the parade, she did in fact touch me multiple times without my permission, only to annoy, harass, offend, and cause me mental distress. She did in fact annoy, harass, offend, and cause me mental distress. Plaintiff went to the local police department, Worcester, Massachusetts, and filed a police report. On July 22nd, okay, before we move on. So, here's the thing. She went to a public parade that he was at. That's allowed. She approached. Josh Abrams said, Oh, look, it's Kate. Would you like to join us? That's an invitation. So it's not harassment when Josh Abrams invited her. Along the parade, she was walking next to Josh Abrams, behind Delete Lawz. Most of the time, chatting with Josh Abrams and occasionally shouting, This is my brother. He's escaped from his mental institution. He's off his meds. Delete Lawz would stop short, causing Kate to run into him. That's not Kate battering him. That's him. He caused the contact. And then, this is on video. Kate's filming. They're right next to cops. He backs into her and elbows her phone out of her hand. That's him. He asked the cops if he could take her down. They said, No, you battered her. This is why, when you're dealing with a fundamentally dishonest person such as Delete Lawz, if you are battered by him and the police ask if you want to press charges, do it. You have to. You absolutely have to. I mean, Kate, I doubt you watch my videos. I don't know what the statute of limitations is in in Massachusetts for this. If it's not too late, you should still file charges because it'll help you. If he had been convicted of battery or charged with battery, it's an easy win. You can never let someone like Delete Lawz off the hook for anything because he he's manipulative. He'll use it to his advantage. On July 22nd, 2022, while I was at the Tahlequah Courthouse in Oklahoma, which is not in California, neither is Boston or Worcester, Massachusetts, and was participating in the press release for a friend, a man I know only as J.L. Warren. J.L. Warren, who has the channel, what's it called? It'll come to me. But J.L. Warren is not Kate Peter, is not David Omo, is not Daniel Clement, and is not Michael Piratini. He is a known party. Delete Lawz has known. Bridge the divide. J.L. Warren, bridge the divide. Delete Lawz knew JL's name on that day. He's not a John Doe, but he's also not named yet. A man that I know only as J.L. Warren, who is a dues-paying member of the Masshole Troll Mafia, showed up there and purposely ran into me and then tried to have me arrested for battery. Mr. Warren has written me dozens of emails and hundreds of text messages harassing me. I've clearly stated to Mr. Warren that I wish no contact with him and that I am not interested in interacting with him. On the same day he purposely ran into me, he called the police on me and tried to press charges against me for battery. I was temporarily detained by police. It was terrifying because Mr. Warren caused physical contact. Thus, I was unaware if I would be arrested or not. Mr. Warren continues to contact me to this day and proudly proclaims, I am a dues paying member of the Massful Troll Mafia. You can sue me, Chili. Yet he has not sued J.L. Warren. And not much more needs to be said about this. It's on video. Delete Lawz was charging after a much smaller man than JL, and JL stepped in between to defend his friend. Delete Lawz was the aggressor in that. Third cause of action for trespass. Plaintiff against all defendants. Still all defendants. Plaintiff incorporates by reference, blah, blah, blah. At several of the places where I have rented property, so your residences, I have suffered trespass from Peter and her agents, where they entered onto the property without permission and committed harm against the property and myself to terrorize me, and in fact did cause significant alarm, fear, and cause damage to the property that required cleanup and repair. On August 8th, 2022, my van was stolen from my driveway. Masshole members on Discord have taken credit for stealing said vehicle, claiming they stole it. Sarcasm. Learn sarcasm. You have a police report with the name of the person alleged to have stolen it. Sue that person. On August 19th, 2022, in a video where Peter published the findings of the Denver Metro Police Department on my stolen van, she published the address where I was staying in Denver on her Discord. Now, if I remember right, he had already left. Well, this is on Discord. When she made a video, he had already left Denver. But then he returned once again to Denver to the same residence, and yeah. But Kate publishing the police report, it's a public it's an official document. It's a public record. Citing public records is allowed. If doxing is harassment, boy, do Team Skeptic and Blue Bacon have counterclaims. Soon after, Peter and/or an agent left a bag of dog feces and card on the front door. I went to open the storm door, which had a lever-type doorknob. When I pushed it down, the lever came off the security. Under my fingers, I felt a gooey brown substance. I immediately dropped the lever. It fell next to the bag of dog feces on my welcome mat. Next, my dog ran up and began licking up the brown, gooey substance. I yelled for him to stop. I smelled my hand. It was chocolate. I looked around. The handmade card on the door read, Kate always wins. See Exhibit 2. Once again, I fully believe that's a false flag. I do not believe anyone but Delete Lawz did that. On October 25th, 2022, while I was staying at a friend's house, my friend checked the mail and found a threatening letter in his mailbox. The letter stated, Dear Jose de Castro, I'm requesting you retract any and all lawsuits for a certain individual. If you proceed with the lawsuits, I will be forced and will post your current address and location. Sir, these little games you play have gone too far and you will be dealt with accordingly. You can run and hide, but we can find you anywhere and anytime. It wasn't hard to locate the address you currently you are currently at, so tell Peter G. Hi. Address. Current address of my location redacted. Yeah, in that case, you've got to put your allegations in your complaint. It's gonna come out anyways. And once again, I 100% believe this is not real. Even if it is real, this isn't Kate. So here are the terms: retract all lawsuits and take down your YouTube channel and find a different profession because you suck as a constitutional law scholar. Signed, we don't stop. Well, if that is real, I 100% agree that Delete Lawz does suck as a constitutional law scholar. While visiting a friend in New Hampshire and Boston in late August, early September 2022, Catherine Peter and or her masshole members left a handful of balloons and a large handmade sign, 3 feet by 5 feet, that read, Kate's Tea Party, that were left at my friend's residence, attached to the old school mailbox. The location is a 450-acre estate deep in the countryside of New Hampshire. For someone to get to the location in New Hampshire, driving more than an hour into the countryside is required. Thus, this wasn't a small endeavor. It took at least one full day to accomplish, and likely two people to erect the gifts left behind. How Catherine Peter knew my location is beyond incredible and would have required massive surveillance or even a tracking device placed on my auto. During that same trip to visit a friend, Peter stalked and marked my location for her troll mafia to then target me at that location. Brazenly, Peter took a picture of herself sitting outside the apartment's lobby where I was temporarily residing. Peter then posted the picture on her YouTube community page that includes over 30,000 masshole members marking my location for further attacks. This is the reason DeCastro fled to the New Hampshire estate, only to be stalked and marked by Peter and her troll mafia again. De Castro immediately left the estate to and the East Coast after Peter had marked his location yet again. Well, once again, I do not believe at all, that the New Hampshire thing happened. He has brought no evidence other than the alleged sign that I fully believe is manufactured. Now, Kate did post a picture of herself to her community page outside the condo tower that Delete Lawz was staying at. It's titled, it's captioned, A Beautiful Night in Downtown Boston. It doesn't say, hey, look, this is where Delete Lawz is staying. I'm right outside the door. No. People were able to figure out which building he was in because it's a really tall building he was staying at the top of. And he showed videos of the landscape out the window of the harbor. So it was real easy for people to hone in on, well, this is the exact location that picture would have been taken from. You track yourself, Delete Lawz. Fourth cause of action for harassment and civil conspiracy. Plaintiff against all defendants. Peter made her first YouTube video harassing me on April 3rd, 2022. The video is titled, BSBT is insane. Yes. Delete Lawz grift. Turtle Boy goes full auditard. The video was over 1 hour long. The video said I was running a grift and a scheme, that I was a schmuck and a sovsit schmuck from YouTube. Next on that video, Peter visits the product store on my website, degrading and disparaging my product offering, including calling a t-shirt I sell A shitty Microsoft Word font typed t-shirt, which is not true. Um, I disagree. I fully think that it is a shitty t-shirt, but that's beside the point. That's Kate's opinion. Whether or not the font came from Microsoft Word is irrelevant. And what damages does Delete Lawz have if it came from Word Perfect instead of Microsoft, the font? Or if it came from uh what Canva. That's the one that people use for creative stuff. What if it's a Canva font? Has Delete Lawz suffered damages because it's a Canva font instead of a Microsoft Word font? No, it's irrelevant. She continued to state, I'm going to recreate his shit poster and I'm going to sell them for $48 and it'll be no profit whatsoever. It'll be exactly what it cost to print on Vistaprint, which she didn't do. She didn't sell his poster, but it painted me in a negative light by purporting that the markup of the products on my online store is a scam, grift, or con. She goes on to also threaten to copy my products and sell them at cost just to hurt my business. These are statements that she made on camera to her 30,000 troll mafia members. As she is fraudulently misrepresenting my product lines, several other of Peter's agents speaking during the video make various defamatory claims about me. Once again, she can talk all the crap she wants about his products. It's her opinion. It doesn't matter. But furthermore, his website was down for months at a time over the period he claims that she cost him money. He wasn't making sales if the website was down. That's not Kate's fault. Although the first video that Peter made was about plaintiff, who is not a public figure or a limited public figure, the videos soon turned into directly harassing me by being directed at me. See the titles of later videos like Sorry Chili, another one of your failures, with more to follow. Additionally, Peter has recorded these harassing videos even in contempt of court orders in a federal lawsuit. Several problems with that. First, Kate has never been found to be in contempt in the federal lawsuit. The court has never told Kate not to make videos about you. The court may have said it would be a good idea not to make videos. She said that to both of you. You continued making videos, but the court has never told Kate not to, and she's never been in contempt. Number two, the federal lawsuit with most of these same claims. You can only sue once. And, I mean, let's even jump into the docket. Okay. November 7th, we have the answer, Kate's answer and Josh's answer. And then the whole voluntary amended complaint. Okay. December 11th, motion to dismiss Catherine Peters' counterclaim. I think it's in here. If it's not in here, I'm not going to look further. Haha, I was right. He says in his, well, and he gets the process backwards. He puts the onus on the defendant. Local rule 40.1 sub G sub 5 requires that a notice of related cases be filed. The counterclaim is missing such notice. Well, if, as was the case here, there are no such related cases, why would you file the notice? Besides which, you would file them as the plaintiff. But to my knowledge, it's not going to be local rule 40.1 G5. And I'm not going to look up what it is in California. But there's going to be a similar rule saying file a notice of all related cases, which, to my knowledge, he has not done. This is a related case. He mentions the related case. The related case, the federal lawsuit. Peter published a video that said, among other things, because you are a quarter of a man, in her video, what to do if you get doxxed. Chili is a quarter of a man. A video that she made after federal court judge Allison D. Burroughs ordered, among other things, defendants are ordered not to engage in any threatening, harassing, illegal, or otherwise inappropriate behavior when engaging with each other. She was not engaging with Delete Lawz. She was making a video about him. That's different. How he think this wasn't contempt. How he thinks this not being contempt is at all relevant to the California court. I just I don't get it. How can you be this dumb? A motion for contempt against Peter is currently pending in that court. Peter has made 70 videos totaling over 170 hours of content about plaintiff. See Exhibit 3. These videos did serious alarm and annoy me and did cause me substantial emotional distress and financial loss. Um, that 170-hour figure is going to almost certainly be vastly exaggerated because most of those videos weren't exclusively about delete laws. But he says this is problematic. He's not going to be sanctioned for it or anything, but it's problematic. Um, this is what happens when you amend your complaint without amending it. He says the motion is for contempt is currently pending in that court. Um, no, no, it's not. We've got the let's see, second motion for contempt, January 16th, and then uh opposition on February 1st, and then emergency motion to strike on February 2nd because Benjamin Wish was late because he says it was calendared wrong because of a funny thing in the docket. Uh, uh, Emergency motion to strike, opposition to the emergency motion to strike. Judge Burroughs finding that Kate was not in contempt and in her order on the motion to mental authority. Well, motion for reconsideration on the emergency motion to strike. Uh, Judge Burroughs endorsing the order, and then finally Delete Lawz going after Judge Burroughs. So it's there. There is no motion pending. Even if there was a motion pending, that doesn't mean she was in contempt. And even if she was in contempt, that's a different court. So ha- how it has any bearing on a Los Angeles judge, a Los Angeles court lawsuit? It, it's meaningless. On May 3rd, 2022, Peter and her agents called my phone approximately 100 times while I was recording a video that I was broadcasting live to my audience just to troll me. What video? See, remember how I said I'm not a California attorney, but Merb is, and Merb has brought up fact pleading. Well, a good fact to have here would be it was in this video of mine, this live stream, that Kate and her agents called me this many times. I received phone calls from this number and this number and this number and this number, and this number is known to be Kate's. I was doing a live fundraiser for a Native American woman that had been illegally arrested on her tribal lands, and I was trying to call her when the telephone harassment began. Yeah, Deborah Rogers was not illegally arrested. Peter and her agents S, I guess if you add an S to Kate Peter, Z, why not to her agents? Z, were watching my live stream and determined when it would be best to harass me. For example, when I needed to use my phone, they called the phone approximately 100 times. You can see this in my video titled Deborah's Story. Oh, so he actually does. Fake Law versus Real Law. Ironton Bad Practices fundraiser for Deborah at timestamp 1458 through 2436. Well, once again, it would be good to have the telephone numbers that called to harass you. Even after I put my phone in do not disturb mode, the harassing texts were continuously coming in and audibly disturbing my phone call with my video guest for the fundraiser. The repeated telephone calls and text messages impacted the fundraising and seriously annoyed and harassed my guest and me. The video is available on YouTube at the following URL. Okay, the URL's at the end of the paragraph. After I was off air, I had approximately 100 missed calls. I tried calling one of the numbers back, and it was a Google Voice number that Catherine Peter had set up with a voicemail message in her voice that said, "I told you never threaten me, Chili." At the sound of the beep, I left a message and asked her to stop contacting me. Peter also hired a man that I only know as Todd Lyon that attempted to befriend and betray me. Todd and I talked several times by email, text, telephone, and even video chat. Eventually, Mr. Lyon admitted that he had been paid $1,000 to attempt to get close to me and then sabotage me. Mr. Lyon has prepared affidavits attesting to these facts. And yet, he submitted an affidavit to the Massachusetts court saying that Delete Lawz threatened him and forced him to create false affidavits. And I still don't know who Todd Lyon is or how he fits into this, but yeah, I, y- yeah. Peter and her agents have repeatedly emailed, cyberstalked, stalked, harassed, and trespassed on my residence. Once again, Todd Lyon is not Kate or Blue Bacon or Team Skeptic. Additionally, they commit wholesale copyright infringement of my creative content in order to harass me. It's almost like copyright infringement is a federal cause of action for federal court. So good luck when trying to claim, oh no, you can't remove it to federal court because by including Todd Lyons, or by including Dan Clement, it destroys diversity jurisdiction, but you're claiming federal causes of action in copyright, blah, blah. It's just, ugh. I have a pending federal lawsuit over the wholesale copyright infringement. These people have even harassed my dog, Charlie. Defendants further refuse to honor any harassment cease requests or cease demands. There are additional events that discovery will reveal and proof provided at trial. So, eh, the these claims, at least against Kate, existed when he filed the federal copyright lawsuit. I mean, they, especially since they existed because they were his original causes of action in that lawsuit before he amended. And we still don't know. The judge has not said these are dismissed. So, as far as we know, these are still in that federal lawsuit. But if they're not, were they dismissed with prejudice because he couldn't dismiss voluntarily? So, but even aside from that, you've got to bring all your claims. You've got to bring all your claims. These people have even harassed my dog, Charlie. Defendants further refuse to honor or I already did that. The masshole members work together to harass me for clout in the organization and constitutes clear conspiracy. The defendants work together in an agreement to commit these wrongful acts. Fifth cause of action for stalking, cyber stalking, and civil conspiracy. Plaintiff against all defendants. Although the Discord was originally created in October of 2019, it gained more users when Peter advertised it on her YouTube channel on May 25th, 2022. She specifically advertised that on the Discord they would establish a Chili Watch page. This was to both stream my copyright videos so that Chili won't get the YouTube views and to track him like an endangered great white shark. These are all great quotes, but they're not cited. Peter also used Wicker group chat in order to track and coordinate harassment and stalking of me. Where's the evidence of that? Further, Masshole members have written in the Discord account and directly contacted me via email that they have planted an Apple AirTag, a commercial tracking device, in/on my vehicle, which made sense to me because they have consistently found my exact location, even today as I write this complaint. So, number one, don't email Delete Lawz, period. Especially knowing that he's a moron that takes everything literally and is going to hold it against Kate. Just don't do it. As Kate says, keep your arms and legs inside the ride at all times. This isn't a petting zoo. Do not pet the exhibits. Just don't. But Delete Lawz. People find you because you live stream in public. You live stream street signs, business signs. It's real easy to find you. Peter and several of her masshole members have written and stated aloud on Peter's videos that they are actively tracking me like an endangered great white shark or extinct megalodon. As of so they're using a TARDIS to track you. That's the only way I could track a megalodon. As of February 3rd, 2023, while live streaming a video titled "The Camera is What Makes You Powerful," a masshole member posted my exact location in the live chat. The masshole member was not Kate. Otherwise, you'd say it was Kate. And it's probably because you were live streaming and it's easy to find you when you live stream. The masshole member went as far as to create a fake username and the true name of the friend's house that I was at. I ended the live stream to ensure my location was safe. I informed my friend that someone has created his exact name as a YouTube username, and he immediately stated his concern for his safety and mine. Then your friend should sue that person. Not you. You, your friend is irrelevant here. He did not ask me to leave, which has happened to me in the past when being stalked by Peter and her troll mafia. Nobody feels comfortable when a troll mafia publicly doxes your exact location. So, doxing is not okay if a troll mafia does it. But if Delete Lawz does it to Blue Bacon and Team Skeptic, that's okay because it wasn't a troll mafia that did it. Even if Delete Lawz passes on Blue Bacon's information to Vegas Valley Community Cop Watch, whatever it's called, who has stated he wants to hurt Blue Bacon, that's okay. But if it's a troll mafia. Then it's not. It's good to know those are the rules. It causes immediate concern for safety. Peter cannot fully control the 30,000 masshole troll mafia members' actions, and she's stated this clearly several times in the past, but she has given them authority to act to harass me. Obvious, malicious intentions exist to cause me and my loved ones fear and panic, which does, in fact, cause the fear and panic. R- Remember, an agency is ostensible when the principal intentionally or by want of ordinary care causes a third person to believe another to be his agent who is not really employed by him. And that should read reasonably believe would cause a reasonable person. Delete Lawz is not a reasonable person. Peter cannot fully control the masshole members. And she has stated in the past that she can't control them. No agency. By his own words, no agency. No agency. You can't make this up. I have been stalked and harassed at my residences in New Hampshire, Boston, New Mexico, Colorado, Nevada, and California. I'm not going to scroll up, but in the party section. And I, Jose de Castro, am the plaintiff and at all times have been a resident of Santa Monica, California. I have been stalked and harassed at my residences in New Hampshire, Boston, New Mexico, Colorado, Nevada, and California. Where have you resided? I have suffered from vandalism. My van was stolen, likely by Peter and or her agents. Masshole troll members on Discord have taken credit for the stealing of my van, stating that it's underwater and it will never be found. Wasn't it found? And I'm just guessing because this wasn't Kate. You say it yourself. It wasn't Kate that says it. So, not Kate stated it's underwater and it will never be found. That's because before an arrest was made, before the police report, people thought that it was an insurance scam. They thought you put it underwater. In the Discord, there is a page called Chili Watch where my location has been constantly and consistently tracked, and Peter and her masshole agents have used this information to cause damage, intimidate, and instill fear into me, but more importantly, to the people around me. I've been stalked since June of 2022, non-stop, and it's still going on today, right now. It does not matter what I'm doing, where I'm going, or who I am with. If I'm live streaming while filling my car up with gas, people from Catherine Peters' Troll Mafia will start calling the gas station attendant at that gas station. Then don't live stream while you're filling up at a gas station. But once again, that's not Kate. And even if it was Kate, what harm did it do it do to you calling the gas station? Did they refuse to give you gas? No. Where's the damage? Where's the harm? It's real. And this entire scenario is on video that will be available at trial. The hosts of accommodations where I stay when I am traveling the country are contacted by telephone, email, and messages through Airbnb. Masshole members will then warn the people who are providing my Airbnb. Did you know that DeCastro is a dangerous man who carries guns and is wanted by the police in multiple states? Which isn't true. You're wanted by the police in Ohio. At least that much is true. On July 29th, 2022, I was attending an MMA gym in Denver, Colorado. A, a charity event fight promoter, I, and a former police officer were putting together a charity event. That's such a terrible sentence construction. A charity event fight promoter, I, and a former police officer. That's just awful. And isn't Chad Goo still a police officer? Wherein all the profits, including the officer's pay and mine, would be donated to St. Jude's Children's Hospital. We had sold almost 1,000 tickets, $40 each, for the event that I took seriously. Thus, I temporarily moved to Denver to join my good friend's MMA training center called 10th Planet Jiu Jitsu. On this day, July 29th, 2022, the owner of the gym, my 20-year-long friend, sent me a text message issuing me a refund and simply stating, "I'm sorry, Chili. I can't get the Google ratings down like this. I'm being harassed like you don't even understand. I just can't. I'm sorry." The harassment of said gym owner continued for several months, even after I left. And that gym owner is not Delete Lawz. Approximately August 1st, 2022. After being a member of Airbnb since 2010, I was unceremoniously and immediately kicked out of my Airbnb in Denver, Colorado. Airbnb would not reveal the reasons why. I've rented hundreds of locations from Airbnb since 2010. As an ad executive in New York City, it's imperative to have the ability to be able to rent Airbnbs quickly. Um, Are you an ad executive in New York? On this date, Airbnb suspended my account indefinitely. You've been assessed to be a risk factor. You are to immediately pack your belongings and leave the Airbnb. The host has canceled your month-long reservation. This on day 2 of the 30-day stay. Please stand by for a phone call from the Airbnb safety and security team. On that phone call, I was told that Airbnb had been alerted that I am armed and dangerous. Are you carrying a gun? Is there a gun in the Airbnb? Of course not. However, a man named Sean O'D, who goes by the name Irish Demon on YouTube and is also a dues paying member of Masshole, previously had posted on his LinkedIn page that he worked as a customer service for Airbnb for over 6 years. It is plaintiff's intention to subpoena Airbnb to find out exactly what happened on August 1st, 2022. Mr. DeCastro has never been asked to leave any rental property from Airbnb and has been maintained a perfect 5-star rating on the application since 2010. After threatening a lawsuit, Airbnb restored permissions to use my account in December of 2022, but I haven't seen the documents yet that caused the suspension. Apparently, Irish Demon is the only Sean in the world. I mean, I seriously see Charlie from Always Sunny with his wallboard with the pieces of string connecting the conspiracy. That's how I see Delete Lawz. On August 10th, 2022, Peter made a YouTube video falsely reporting that my van was repossessed, simply to further harm my reputation and to further harass me. This, even after she had attained the Denver Police Department report that my van was indeed stolen. Denver police would later arrest and charge a woman for stealing my van. Peter has made no retraction or corrected her erroneous reporting. She made a video with the police report about the arrest. She never reported that your van was repossessed. She speculated about it being repossessed. There's a big difference. On October 6th, 2022, while me and my roommate were walking home from the market in Santa Monica, California, while maybe 50 yards from my permanent residence, a man pulled up to us in a vehicle with Florida license plates and yelled, "I see you, Chili. I know where you live. Kate always wins," and then quickly drove away. This caused great alarm and fear in my roommate and myself. We went through weeks of infighting because my roommate feared for his autistic son's safety. It's beyond reasonable for Masshole Troll Mafia members to show up at my house and threaten me, my roommate, and my safety. If I recall, they didn't threaten his roommate. They yelled, "Nice to meet you, Mr. Condon." And Mr. Condon smiled and waved. That was great alarm and fear. And a man in a vehicle with Florida plates. Last I checked, Kate is not a man from Florida. My mother, immediate and extended family members, as well as dozens of my small town friends in Alaska, have received many harassing phone calls. I graduated with 62 young men in 1992. Most of them have been contacted by Masshole Troll Mafia members. You make yourself newsworthy, people are going to call acquaintances for their story. That's not harassment. If it was harassment, NBC News would be sued by every single person they talk about. My roommate, David Condon, has received harassment, trespass, and vandalism. Previous investors, colleagues, and coworkers have received both calls questioning who I am and also warning that I have become a danger to them and they should stay away from me if they know what's good for them. One of Peter's agents, that I know as David Omo, has been continuously emailing me, often multiple emails a day. Omo's email content has escalated to warnings of violence and then to actual threats of violence, including references to his felony criminal record to make them more credible. Piratini has been sending me harassing emails forged to look like they're from a court 2 to 3 times a day since at least November 2022. Team Skeptic, well, he should stop emailing Delete Lawz for starters. But you already brought a restraining order against him in California, which the court didn't find credible. It was laughable, even. Blue Bacon has sent you real court records. Just because you don't believe in them doesn't mean they're not. I have had dog poop left on my porch, my outside door handle covered in what looks like poop, and my external door handle removed. I have received gifts of balloons and cards about Kate's tea party left at my residence. Isn't that nice? They gave him gifts. Peter has posted pictures of herself on her YouTube page in front of one of my temporary residences. Peter has paid a man $1,000 to try to get close to me and sabotage me. I have the receipts and the man's affidavit stating these facts. As a result of the foregoing, I have legitimately feared for the safety of myself, my family members, and my associates, and am constantly in a state of alarm. The Masshole Troll Mafia members work together to stalk me for clout in the organization, and this constitutes clear conspiracy. The defendants work together in an agreement to commit these wrongful, illegal acts. There are additional events that discovery will reveal and proof will be provided at trial. In this scope, but not limited to it, Catherine Peter will stalk, harass, and assault any person who plaintiff DeCastro recognizes or associates with. From August 27th until September 11th, 2022, Catherine Peter stalked, and harassed Zane Kane, the man whose residence DeCastro had stayed at in New Hampshire and Boston. When they could not affect Mr. Kane, Troll Mafia members then found the owners of the property where Mr. Kane was residing. Troll Mafia members warned the landowners, a Harvard professor, and her husband, a venture capitalist, that Mr. Kane's friend, DeCastro, was armed, dangerous, and wanted by the FBI. All lies. Plaintiff DeCastro had already left the East Coast and was not there to defend these lies. Mr. Kane was fired from his job and lost both of his residences as a result of the stalking. Last I checked, Zaner is not Delete Lawz. Peter would go on to make several videos about Mr. Kane, who had no relationship with her and had never even met her. Approximately January 27th, 2022, Plaintiff DeCastro publicly recognized a YouTuber named Regan Benson. 3 days later, on January 30th, 2022, defendant Peter made a video about Benson titled The Reagan Benson and Denver Metro Audits Mystery. This is an attempt to alienate and disrupt the First Amendment auditor community that DeCastro is a part of. Regan Benson had never previously been mentioned or referred to by Catherine Peter. It boggles my mind how he thinks that's harassing him. Kate Peter has been making videos about First Amendment auditors since long before she'd heard of Delete Lawz. She's made videos about Denver Metro audits, who I guess is friends with Reagan Benson. Denver Metro audits doesn't need Kate's help to alienate Delete Lawz. He thinks you're a joke. The wider First Amendment, like every single First Amendment auditor I've seen talk about Delete Lawz, thinks he's a joke. They do not like him. That's not Kate's doing. Sixth cause of action for assault. Plaintiff against all defendants. On October 14th, a member of the Masshole Troll Mafia, who I know only as Dan Clement, began plotting to get into a physical altercation with me in order to, at his own admission, cause me to lose possession of my firearm. Where did he begin plotting this? I mean, when he pulled this stunt, Kate threw him out of the Discord. So Kate certainly didn't endorse this action. In the Discord, I saw, I don't know the validity of this, but apparently he planned this on one of Sovereign Soul Unchained Minds live streams. He's not Kate. Dan Clement isn't Kate, and certainly not any of the other defendants. Clement had been in a fight in his past where he had a restraining order placed on him, and so he was aware of the repercussions of them. He wanted to use this tactic to cause me to lose my firearm. On October 17th, armed with bear spray and a tape measure to measure my height, Clement used the group's Discord Chili Watch page to receive coordinates, plan, and get real time logistics of my location from several other Masshole Troll Mafia members who were tracking my location in real time. You were on Hollywood Boulevard. Hollywood Boulevard is a world famous street. It's not hard to find you. If a tape measure is coming armed, then my mom is constantly armed. She's got one of those little 3-foot tape measures in her purse. Maybe I should have borrowed that along with her coat. Clement quickly found me while I was working as a reporter for my YouTube channel and engaged with officers of the Los Angeles Police Department. While busy working, Clement, with the help of the Discord Chili Watch tracking page created by Peter, Clement approached me and said, "Kate always wins." Then he repeated it. "Kate always wins, Chili." I addressed Clement, then I asked him to leave me alone, and I walked the other way. Every action I'm describing here is on video for this court to review. Clement followed me and said that he could beat me up. "I could hold you down and then ground and pound you. Look how little you are," he exclaimed. Again, I walked away, went the other way, and quickly down the block to avoid having to protect myself from this stalker. Well down the block, moments later, Clement approached me again and somehow managed to corner me. After trying to go left, Clement blocked me. I tried to go right. Clement blocked my path. I took a fighting stance, ready to defend myself, and announced to Clement that I would now begin an offensive defense. Now that I was visibly angry and ready to defend myself, Clement ran away, quite literally crying, "Please don't hurt me! Please don't beat me up! I'm sorry!" Clement was then assisted by people who plaintiff could only believe were members of Catherine Peters' Troll Mafia Club, who came to Clement's assistance. Apparently, everyone everywhere is a member of the Troll Mafia. Clement would then appear on Peter's Discord and claim victory for trolling me. Remember, Clement brought with him bear spray, rope, and a measuring tape, which would cause any reasonable person to fear for their safety. And Kate kicked him off of the Discord for that. I did believe that I was going to be attacked by Clement. Clement did, in fact, threaten me, both verbally and was using physically menacing body maneuvering. I believed that he was going to carry out a physical attack onto me. Clement did, in fact, stalk me, menace me, and cause me ongoing mental distress, fear, and alarm. Clement continues to contact me to this day. So, other than seeing that video, I have no idea who Dan Clement is. Of any of the defendants in this, Dan Clement is the closest to being responsible for what Delete Lawz is claiming. I don't think it rises to that level, but Clements might not be dismissed on the California equivalent of a 12b6. That being said, Dan Clement is the only person who has been served in, in this lawsuit, as far as I know. But, and I haven't done research on it, I see a pretty big technical violation in that service, so it might not actually be valid. I'm not going to say what that violation is, that technical problem, because I don't want to give Delete Lawz any help. And speaking of service, I don't know if I have it up. I don't want to score it. No. Let's see. Oh, we'll give it another minute, see if it loads. I'm not going to worry about it. Delete Lawz. The most recent filing in this was that, oh well, my process server tried to serve Kate but hasn't been able to because he tried serving her at 9 in the morning when Kate works a full-time job. Delete Lawz is trying to, well, look, I don't need to serve her because I've tried and failed. She's not dodging service, she's going to work. So, moving on. Seventh cause of action for economic interference. We're getting close. Plaintiff incorporates by reference paragraphs, blah, blah, blah. On May 2nd, 2022, Peter contacted David Condon, an accredited investor who had previously invested in my company. Condon has invested approximately $100,000 into my ventures through the years, and he and I had formed a close friendship. Condon told me that Peter wanted to interview him about my previous tech venture. Condon agreed, and on May 3rd, 2022, the two talked at length on the phone. During the conversation, Peter did her best to paint me in a negative light. Condon has prepared an affidavit and will testify at trial. Once again, interviews are not harassment. Interviews are not tortious. On July 6th, 2022, Peter called David Condon dozens and dozens of times and sent him approximately 100 text messages. Mr. Condon is an accredited investor and a 65-year-old man. The messages and people on the phone only said one thing, and the text messages said the same thing. That message was, Kate always wins. Peter knew of the agreement between Condon and I. Peter intended to cause breach of contract and did, in fact, harm the business relationship. Although Condon has prepared an affidavit, Peter's conduct was a substantial factor in Condon not investing any further in my projects. What what future projects has he not invested in? Eighth cause of action for right to publicity torts. Plaintiff incorporates by reference paragraphs 1 through 71, blah, blah, blah. Defendants have used my likeness to advertise most of their YouTube videos about me. The defendants gained a commercial benefit because their following, as well as my following, were looking for content about me and used the images to find the content, which earned advertising revenue for the defendants. I was harmed by not having that ad revenue myself, by the videos containing negative content about me, and because, as a trained actor, I charge fees and have been paid for my likeness. As a direct result, I have suffered financial loss, momentum to grow my brand, humiliation, embarrassment, mental distress, and economic harm. Once again, you can use there's fair use here. If not, newspapers couldn't include photos of the subject of their stories. NBC News couldn't use videos or photos of the subjects of their stories. It's just it's absolutely asinine. Now, if people are putting his likeness on merchandise, that could be a problem. Now, I don't know that anyone's done that. I certainly don't think Kate has, or Blue Bacon. Now, some channels, none of these defendants, as far as I know, uh, their merch has gone a little closer. Not with Delete Lawz, but you know, there's some questionable merch out there. So be careful. Don't use other people's likeness. But I haven't seen anything for him. Prayer for relief. Plaintiff prays for judgment against defendants and each of them as follows. Enter an injunction for any and all appropriate injunctive relief, including, but not limited to, issuing a retraction in substantially as conspicuous a manner as the original defamatory statements were published and broadcast, and removing the defamatory information from all places where it is currently published online. A declaration that the defamatory statements were untrue. An injunction prohibiting defendant from repeating such defamatory statements. Declare a judge and decree defendants violated the relevant provisions of California Civil Code. Order defendants to pay $750 to plaintiff for his right to publicity violation in pursuant to Civil Code 3344A. Order defendant to pay $500 to license my likeness for each use customary to my sitting rate. Dude's not getting $500 anymore. He may have got $500 in the past. He's not anymore. Order defendants to pay revenue earned for unlicensed use of my likeness according to proof. Order defendants to pay $50,000 for damages and lost income for defamation. Order defendants to pay $100,000 to plaintiff for damages for her interference with economic relations. Order defendants to pay $250,000 for special future damages from the defamation. Order defendants to pay any additional special and general damages according to proof. Award exemplary damages and $86,000 in punitive damages pursuant to the requirements of Civil Code Section 3294. Award plaintiff attorney's fees and costs of suit. There are no attorney's fees. Order defendants to pay interest at the legal rate on such damages as appropriate, including pre and post judgment interest, and grant any further relief that this court deems just and proper. Dated March 14th, 2023. Jose de Castro in pro per. So, as I've been pretty clear, as to all the defendants, he's not going to win anything. As to all the defendants except for Daniel Clement, I think it's dismissed on the California equivalent of a 12b6. Um, there could be legal maneuvering in between. They could remove it to federal court. They could sever the case, make him prosecute 4 separate cases because, frankly, all of the allegations against all of the defendants involve separate stuff. Not, none of them need to be in the same case. So they, if they see it as advantageous, they can easily sever. So I've mentioned in the past, Kate's has fundraised for the Massachusetts case. She Even if she lost, she's not, as far as I know, she's not going to be collectible. Um, so in Blue Bacon's video covering this, he's the only one that I affirmatively know owns his own house. He's stated as much to my statement to him in the comments. Um, I said, if you own a house, contact your homeowner's insurance. They may have a duty to defend you here, a la Amber Heard. Uh, he said, as a matter of fact, I do own a house because I work hard for my money. So, at the very least, Blue Bacon could have an insurance funded attorney depending on the outcome, and that could get expensive for Delete Lawz. But with that, I've rambled long enough. I think I did have more detail in my other video. Feel free to watch that after watching this or instead of watching this. But with that, I think I've rambled more than long enough. I'm certainly tired of rambling, so thank you for joining me. Do all the YouTubey things, like, share, subscribe, and I'll see you on the next one. Have a good one. Bye bye.